a positive change that we've been seeing recently, at least for my clients who have strong cases, is that processing times have dramatically improved. It's common now in some parts of the country, including the New York area, for a marriage-based adjustment of status to go from filing the application to being a permanent resident in 3 months. It's amazing. And if you have a strong green card application, no criminal issues, no other inadmissibility issues, no fraud, no deportation orders, those people are benefiting from this policy. Hey guys, for those of you who are new here, my name is Puyan Darian. I'm an immigration attorney and I focus my practice on marriage-based green cards. So today's video is going to be about some of the changes I've seen to the marriage-based green card process and answering some of the questions that I commonly get during consultations with newly married or fiancés who are about to get married immigrants before they decide whether they want to apply for adjustment of status or hire me to help them, or they just have some questions. So anyway, if you're considering applying for a marriage-based adjustment of status or you have an application pending, this video is for you. So the first change that we're seeing is that denied applications are being referred to immigration court to begin removal proceedings. This is having a chilling effect on applications. People who might qualify are holding off on applying, understandably, because if their application is denied and they're placed into a removal proceeding, that's going to be very expensive at the very least. So, I have some clients who might qualify for permanent residence through adjustment of status, but they're going to need a waiver for some sort of old crime or immigration related fraud or misrepresentation. And my general advice to these people is, there are risks involved. If we apply and then your waiver is denied, you're going to be placed into removal proceedings, and that's super risky situation to be in. But on the flip side, being completely undocumented and out of status is also a risky situation to be in. So we need to weigh the pros and cons and make a case-by-case determination as to whether it's in your family's best interest for you to apply right now. And if things don't pan out the way we hope and you're placed into deportation proceedings, what next? What options do you have available? What defenses from removal would be available to you? Do you have a strong defense? Do you have a weak defense? So when we go through all this, we can create a reasonable calculation as to whether it's worth it to apply right now and whether that risk is outweighed by the risk of doing nothing. Now, on the flip side, a positive change that we've been seeing recently, at least for my clients who have strong cases, is that processing times have dramatically improved. It's common now in some parts of the country, including the New York area, for a marriage-based adjustment of status to go from filing the application to being a permanent resident in 3 months. It's amazing. And if you have a strong green card application, no criminal issues, no other inadmissibility issues, no fraud, no deportation orders, those people are benefiting from this policy. Now, on the flip side, you can go from submitting your green card application to being in removal proceedings in 3 to 4 months as well. And I think that's really the main impetus, the main purpose of this policy, is to just fulfill Trump's campaign process of deporting a record number of immigrants. So you're either going to be a permanent resident or in removal proceedings at the end of your adjustment of status application, unless you're in some other sort of status simultaneously. For example, if you're on an H-1B visa and your adjustment of status application is denied, you'll probably still be able to stay on your H-1B visa unless you violated the terms or conditions by using your adjustment of status work permit to change employers. The way you changed employers was not in compliance with your H-1B, so that would be a different situation. But generally, this has been positive for most of my clients. People are thanking me for getting their cases approved so quickly. It had nothing to do with me. It's just these policies. And of course, we do the best job we can to make the case as strong as possible and prepare you for the interview. But these processing times are not the result of your attorney. One of the other major changes we've seen recently is that USCIS is now actually requiring people to bring their own interpreters. Historically, when you get an interview with USCIS, your interview notice will say you're responsible for bringing your own interpreter, but then you bring your own interpreter and USCIS officer tells you, we don't need to use that interpreter. We have our own telephonic interpreter. They call this company up, this private contractor with USCIS, they get them on the phone, and that telephone interpreter will do the whole interview in the immigrant's language of preference. That is no longer the case. Now you must bring your own interpreter. There was a recent USCIS press memo on this. And since then, some USCIS offices have been giving applicants a grace period. Some have been strictly enforcing this. Some have been just rescheduling interviews for people who show up without an interpreter. Just be on notice that you must bring your own interpreter now, or it is possible that your adjustment of status application will get denied. And if it gets denied, you'll be placed into removal proceedings. So massive consequences for minor mistakes right now, so just be aware. All right, guys, one final little bonus one. This is a small change, but it's notable. USCIS officers now prefer for you to upload any additional evidence that you want to present at the interview in advance of the interview. This saves a few minutes when you show up to the interview. For example, let's say you're going to go to your marriage-based adjustment of status interview with your spouse, and you applied for your green card 3 months ago. So all of the evidence of your marriage that you submitted is at least 3 months old. But since then, you guys have gone on a new trip. There are some photographs of that trip. You have like 2 new bank statements. You have a new health insurance document. You should organize all of this stuff and upload it to the USCIS portal for your I-130 petition as unsolicited evidence a couple days before your interview. I generally recommend like 5 days before your interview, and then bring that evidence with you to the physical interview. And if the immigration officer, when they ask you, do you have any updated evidence? Your answer can be, yes, I have a folder of updated evidence right here, but I also uploaded this stuff and labeled it like 5 days ago. The officer might appreciate that because they will not have to take it from you and now go and scan it and label it and figure it out. But they might say like, oh, great, I'm so happy you uploaded it, but can I just get the physical copy from you because it'll be easier for me to review everything out on my desk. I don't like to look at things on my screen. That's possible. So my general recommendation is upload it a couple days in advance and then bring a copy of everything with you. And of course, bring all of the original documents like birth certificates, passports, marriage certificates, divorce certificates. All of the original stuff still needs to be brought with you to the interview. I also bring a copy of everything we submitted, but hopefully you won't need to show the officer much of your updated evidence if you've already previously uploaded it, and it might reduce the amount of time that you're in the interview. And generally speaking, less time in the interview means less time for things to go wrong. So it is my preference now to submit the evidence a couple days in advance of the interview. But if you don't do it, or you're not tech savvy, or you don't feel like doing it, it's not a big deal. You could also just bring it with you to the actual interview. All right, guys, that's the end of today's video. I focus my practice on marriage-based green cards. So if you're interested in applying for a family-based adjustment of status, whether it's for a spouse, parent, or child, my name is Puyan Darian. I focus my practice entirely on these types of cases. So I'm your guy if you need assistance. You can find my information for scheduling a consultation in the video description below. You can also go to my website, darianlaw.com, and click the booking link. It takes like 5 minutes, and I look forward to speaking to you guys. All right, guys, thanks for watching, and I'll see you guys next time for another video.